further in trouble because you can determine that they're not remorseful, or they want to make it, and they want to make excuses, or they want to blame everybody else for that. And those are things that I just don't feel that they should say at sentencing. Um, you know, we had a case, Aaron and you and I had, where over in Presque Isle, and that was a couple of years ago, and I know this topic came up before, where we actually had a full trial. I won the trial, and then my client decided to just mouth off to everybody because he had won. Problem was, he also had a contempt hearing right after that for something he'd done while he was on bond. And so he ended up going to jail just because of his antics, how he was acting in the courtroom. And how often do you win a trial and your client still leaves in handcuffs?
Yeah.
So yeah, you just evaluate what, and he deserved it. There was no doubt about it. So you sort of have to evaluate and figure out if you think they're going to harm themselves.
Okay. Yeah, and the other related questions to that is issues like respect for the courtroom decorum or their attire. Does that have any impact on the sentencing decision? I mean, I'd say very, very little. I try to set those things aside. And then does the judge's mood affect the sentence? The only thing I have to say about that is I hope not. And if any of you ever think that's the case, maybe ask for a continuance or something. I don't know. There was one time in the last few months when a defendant started explaining during his allocution, and the statements he was making, I found to be so offensive that I found myself flat out mad at him. I was angered by what he said. And I was so angry, I actually said, I'm too angry to sentence you right now. So we adjourned it and came back a month later for me to, reconsider with more of a cool head, I guess. So that's the only time I can think of that my mood was starting to interfere, and I tried to prevent that.
There was a study, though, done a few years ago determining sentencings between how judges sentenced and how their college football teams had done over the weekend.
Well, it's a good thing I root for the best college football team in America, the Notre Dame Fighting Irish, then, because I'm always happy.
And there's a reason Melissa and I have a chart on when they win.
Right.
I was going to say, as far as the clothes too, I think it'd be important for the public to know that, sometimes it might not look like something you would wear to court, but really it's the best thing that person has in their closet. And I don't know if they realize that sometimes for trial, defense attorneys actually have to go shopping for their clients so that they do look well in front of a jury.
Okay, good point. There were a few questions about, there were a couple of questions at least. Why are some discussions held in chambers or off the record? What are the benefits of those discussions to be in private rather than in the open courtroom? Are they mainly just to streamline the caseload for the day, streamline it? So from your perspectives, why do we have those discussions, and what benefits do you think that they have for you?
Well, I guess I'll go first. I think I've let Melissa go each time, put her on the spot, but I can think of three right off the top of my head where we would ask for either a sidebar by the bench where we don't want to broadcast over throughout the whole courtroom, or an in-chambers conference where both the prosecution and the defense are there. The first would be if it's obviously of a personal matter. The judge is sentencing a trial for a specific date, and I'm going on vacation. I don't necessarily want to broadcast that my house is going to be empty for the week of such and such, over YouTube or even in a courtroom on a criminal docket day. So to tell personal information to the judge and the prosecutor, so maybe we can schedule something at a different time. The other thing would be is I think it's something that might offend my client. There's numerous times that I'll ask for a sidebar and, tell the prosecutor and the judge that, and they wouldn't know this because they don't have the same contact. Well, that my client has a learning disability, or my client has mental issues, or it has some medical issue that maybe my client would be embarrassed if it was broadcast out in open court. So that would be another reason to protect the client from things just being put out in the public that they might be sensitive to. And then the other one I always think about is maybe I have a client that is going to work undercover or do something with law enforcement. Obviously, they're not going to be very effective if I announce that out in the courtroom and everybody hears it. So that's something the judge would have to know, and the prosecutor would know. The prosecutor would know that anyhow, but it's something that we should relate to the judge. So those are some items.
Okay. Anything to add to that, Melissa?
And similarly, if it's something personal about a victim that shouldn't be on the record, I think that the defense attorneys do a good job protecting them, and I try to do the same for defendants' personal information.
Yeah, I mean, I agree that sometimes it's a sensitive topic that would either be something personal to the lawyers or myself, or it would be embarrassing to the parties. Also, sometimes I appreciate when the attorneys will come talk with me ahead of time if there's a plea agreement that they want to place on the record that's really fairly unusual. And they know that, just on paper, I might look at that and say, well, what in the world is that about? But there might be reasons for that. And some of them might be sensitive reasons, just to explain, give me kind of a heads up on that. Or then just to give me like a heads up on some issue that's coming up. Or I know I have sometimes done that to the attorneys where I'll give you a heads up. Hey, I don't think I'm going to follow that sentence agreement. Here's what I think I might be doing, but I'll listen to what you say on the record, just so that I don't sandbag you all the time. I think sometimes that happens, but those sidebar conversations can be helpful so that we just have or like a guideline scoring issue. So I might call counsel in chambers or to the bench and say, hey, I have a question about OV 13. Again, we don't always do that ahead of time, but the times when I remember to do that, I think things go smoother. Similar to that, are there any rules in Michigan about ex parte communications between the attorneys and the court? Do they apply to email? And the answer is yes, they apply to email. Yes, there are rules. There are lots of rules about that. The gist of it is I'm forbidden to have a conversation with one lawyer without the other side's lawyer present if it's anything about the substance of the case. I am allowed to have one-on-one conversations if it's about a procedural question in the case, only if we need to have that real quick. And then I have to disclose that I had that conversation with the lawyer on the other side. And then obviously discussions are allowed if they're not connected to a case at all. I can see Jim in the hallway and tease him about Michigan State or something like that. That's no problem. Any other thoughts on that, or also on what kind of off the record communications occur? I think you covered them already between defense and prosecutor that don't involve the court. Any other thoughts on any of that?
I think too, it's brought up a lot. Sometimes people think that, if Jim was asking you, who won the football game in the hallway, that somehow that influences the case. But I think it's important for people to know we see each other all every day. But when we're in the courtroom in our roles, we're all doing our jobs, and it's different than socializing in the hallway, that it doesn't impact one way or the other.
Yes.
And I think I would go along with that too. And I think we're also super sensitive to that. We know that we're in a small community. We've known each other for years, and we go probably above and beyond to make sure that there's no even an impression of impropriety or anything like that. Because, I bump into the judge in the grocery store. Yeah, I'm going to chit chat for a second, but it's never about a case. The same, in all my years of practice, I've never had to worry that I thought a judge or a prosecutor or defense attorney was getting the ear of a judge in private. We just really make sure that doesn't happen so that there can never be, like I said, even a viewpoint of it, or even an appearance. That's the word I'm looking for, an appearance of it.
Yeah, and there are rules about that. And if they're broken, attorneys can lose their law license and judges can get removed from the bench. There are bodies that can do that. But also, I think I referenced this earlier too. I mean, all three of us and a lot of the attorneys in town, any that have practiced for a while, we all know each other. We all have know each other generally, with rare exception in the local bar. I think the attorneys all get along. So certainly the three of us, we know each other, we respect each other, we like each other. But then this is where the law is not for everybody, because I said earlier, sometimes we're all irritated with each other, and that happens because of the cases we deal with are so important, and each of us bring different perspectives and different priorities to it. It would be troubling if we were never irritated with each other, because these are really high stakes and really important things. So, but we all can set that aside. And if someone's unable to set that aside, maybe the law is not for them. Because you do have to argue a lot and go to battle a lot, and then still be able to interact in a decent way with people. Couple of questions about defense representation. Do all local law firms have to take appointed cases on a rotating basis? No. And then how, this is more for you, Jim, how in theory or practice might a defendant expect their case to be treated differently if counsel is retained instead of appointed?
Well, I don't know if it's necessarily would be that it's going to be treated differently. Just to update whoever's the viewers, is that the state of Michigan a few years ago came through and really put in requirements for being a public defender. And that sort of goes back to the firms have to rotate. They can't rotate because a lot of the attorneys haven't gone through the training it takes to take court-appointed cases. I know next month I'm in training. They have special rules now that if you haven't practiced for a certain amount of time, you can't do indigent defense work for a county. The biggest difference I would see, and I really think the MDIC attorneys or public defenders or Office of Appointed Counsel, I do believe that they have or are probably as efficient as anybody because of doing it every day. They know the forums that they're in. They know the judges. They know the prosecutors. They're on top of their game. Where the biggest difference I think you're going to see between retained counsel and the public defender's office or office of assigned counsel is probably in the amount of time that you get. I get to my office, there's numerous telephone calls. I can't get to everybody. I can always tell everybody that there will never be a time that you've gone into court and you have not talked to James Gelbert. But every time you call my office, I'm not going to be able to talk to you because I have quite a few cases and I have to get to everybody. Where retained counsel doesn't have that type of volume in cases, and they get paid for sitting on the phone and talking to you. So there's an incentive for a retained attorney. And if somebody's looking for that type of hand-holding or one-on-one, retained counsel is definitely the way to go. But just I pulled some numbers real quick. Our office, and I'm focusing on Sheboygan County right now, our office in 2019, 19, we did 610 cases between 3 attorneys. When COVID hit, that number dropped down to 449, and then those COVID numbers were moving because of over a little bit into the beginning of this year, but as of July, we're at 326. So you don't get as much one-on-one time with the attorney as some people, I'm sure everybody likes, or some people want. So
now, Melissa, from a prosecutor's perspective, I mean, obviously the types of issues that a lawyer might raise in defending a case could certainly have an outcome in how the case might go. So, legal representation matters, but in a general way, does it matter to you whether a defendant is represented by a public attorney or a private attorney in how you would approach the case?
No, in fact, that's something that should really never come into play on who the attorney is and have that influence the offer. I think I'm conscious of that. And I think that the defense attorneys also watch that, and that's never been raised as an issue. It's about the case.
Well, that leads into the next topics that we got were about plea bargaining. How do you, as the prosecuting attorney, I mean, for people that don't know, I think most folks watching might know, our state constitutional system gives the Office of County Prosecuting Attorney a tremendous amount of power and authority. That's why they're elected by the people. Then they're the chief law enforcement officer in a county, and they have 100% charging discretion. So it's not up to the other lawyers. It's not even up to the judge whether somebody is charged with a crime, what crimes they are charged with, what crimes the charge might be reduced to. That is 100% within the discretion of the elected prosecuting attorney. So how do you approach then a case? What factors might go into whether a plea bargain is offered, and what type of plea bargain is offered?
There's actually a lot of factors, I think, that go into a plea offer, whether it's through reading the investigation, talking to the officers, talking to the defense attorneys as they inform me more about the defendant and who that person is, as well as getting the input from victims. So sometimes I can make everybody happy, sometimes I make nobody happy, and sometimes it's a mixture.
Okay, yeah, and I think I worked as an assistant prosecutor for a time. I never had the job that you have of the elected prosecutor, and that's a lot more responsibility and weight than I had to deal with down there. So I know that there's a lot involved in it, though, and I do think it's unique in that you have the only job where you are guaranteed to make everybody unhappy in the criminal justice system at some point in time. Defense attorneys are going to be unhappy with you from time to time. Judges are going to be unhappy with you from time to time. Police officers will, crime victims will, sometimes the public or segments of the public about a case, witnesses and defendants. So like every possible player in the criminal justice system at one time or another is going to be unhappy with the prosecutor. So that's a very, very difficult role. How do you navigate that with paying attention to input from people that matter to you, but without, I guess, without realizing that haters are going to hate, and realizing that you're not going to make people happy all the time?
Yeah, I think it's almost on a weekly basis that I hear you were too easy on a case and you were too hard on a case in the same week, and sometimes about the same case.
Okay.
But I think that you have to find your voice and your goals and your sense of fairness, and try to make sure that you're listening to everybody, but find your path.
Okay. And then we had, I guess one more question about plea bargaining, I think is a good one. And I did a video on plea bargaining, so I might sit out this conversation. Folks can check out my thoughts on that. But I think it'd be great to hear the perspective of you both. What do you think are the benefits of the plea bargaining system, and are there risks to it, including, is there a risk that an innocent person might plead guilty for fear of the greater charges that are levied against them?
Who's going first?
I don't care.
Go ahead.
I think that my fear as a prosecutor, one of the worst things I think I can do is ever prosecute somebody who's innocent. So I think that I always have that in my mind, that I never want to do that. That is against my job description and what I'm here to do. So I try at all costs to prevent that.
Do you think that the plea bargaining system as a whole works? What are the benefits of that?
I do, because I think it takes into consideration factors where sometimes it's a good person that made a bad decision, or sometimes it's a really bad person that is a danger to the community. So through the plea bargaining process, you can make some of those determinations.
Jim, what about the defense perspective?
Well, and I think we definitely need the plea bargaining process. There'd be no way that our judicial system would function without it. And it's a cost benefit analysis right from the get-go. I don't believe any county could afford to try every case as they were charged. And I always joke a lot that there's a public defender economics course that I think I have to explain to people all the time, but a lot of our clients have free representation because they're indigent. And when you have free representation, it doesn't cost you anything to go to trial. And so if we receive an offer or a plea that says plea to the charge, it doesn't harm our clients to take it to trial. And so if that's always going to be the case, that once you're charged with something, either you plead to it or you go to trial, there would be no end to trials, especially when it comes to the public defender's office. If you're retaining an attorney and you're saying, well, I did do it and they didn't charge me that hard and it's going to cost me a ton of money to go to trial, then that's a consideration that somebody retaining an attorney would take into consideration. But in regards to when the Constitution says that you get an attorney and one's appointed if you can't afford one, or and the statutes have said that, then when we've given that right to people, then the plea bargaining process has to come into effect. And a lot of times, too, from the defense's perspective, it's a happy medium. Do I think there's the possibility that somebody might plead to something and they're not guilty of it? Absolutely. There is that possibility. And I do have those conversations with clients. One thing I can say about the prosecutor's office, I do agree with Melissa that she does take a lot of consideration into and listens to us when we say, it might not have went down quite that way, and she does listen to that perspective. We don't have a prosecutor's office that's just trying to get convictions. I can definitely say that. And but I think about different plea agreements that I've presented to clients where they're charged with maybe a CSC first, which if they're found guilty by a jury, they're going to prison for a long, long time. And if they take a plea, it's to a CSC fourth. As I tell clients, at the end of the day, they're the ones with the skin in the game. They've got to make the decision. If we lose, I go home, and that they're the ones that have to deal with the penalty. So yeah, I do believe that there's that risk that it could happen. It doesn't happen a lot, but it could happen.
And I think I did a whole video on plea bargaining, so I'll just refer people to go check that out for my thoughts on that process. Jim just said something that, we have a prosecutor's office that's not just trying to secure convictions. And I want to make sure anybody viewing understands that that's a high compliment and that's correct. That people might say, well, isn't that her job? And Melissa said something about that's not doing my job. And that's right, that the law has always recognized a prosecutor's job is not to secure convictions, but to do justice. And so that means if what is just is getting a conviction in that case, well, then that's the prosecutor's job. If what is just as they go through the case is to dismiss the case, then the prosecutor's doing their job if they dismiss the case. So I just want to make sure people don't misinterpret that comment, to Melissa's detriment. The final area that we had a couple of questions about were the Zoom and YouTube. One of them was interesting. How does a court assert jurisdiction by video over a defendant who's at their house? And I thought I could answer that real quick. Jurisdiction is not conferred by your physical appearance in court. That's always been true. If a defendant is charged with a crime and they're issued an appearance citation and they don't show up, they will get arrested, even though they've never been physically present in the courtroom. The court has jurisdiction over that case and over that person based on what they did in that jurisdiction. And the same thing in a civil case. If you get sued and you decide, well, I'm never going to show up in the court and therefore they don't have jurisdiction, you're going to get a default judgment entered against you. So jurisdiction has nothing to do with somebody physically showing up in court. It has to do with the actions that they committed in the court's jurisdiction. So that's that. But then another question, why are the trials not on Zoom or YouTube? Aren't they public as well? They are public, but I'm not putting them on the YouTube platform, mostly due to some practical issues. If you watch our stream, you'll see the jury box. And so if you show up for a jury trial and you're a juror, I have a legal obligation not to put your face and likeness out there in the public on video. There's a law about that. So I can't put the jury trials on YouTube the way we're configured. It would show the jurors' faces. We did do one trial that we put on YouTube where we had the jurors out in the gallery when we were not providing public access in the courtroom last summer. It ended up in a mistrial due to a COVID issue, but we're not intending to put the jury jury trials on YouTube for practical reasons. And also there are some issues with, for some types of trials, it would be a problem with, say, child victims of sexual assault. I think putting their testimony online would be problematic. Any thoughts on that from either of you? Or I guess just in general, lots of courts and lots of judges are doing this differently. What I'm doing right now is putting the criminal cases still on YouTube, the civil cases still on YouTube, family law cases I'm not putting on YouTube, and trials, jury trials, I'm not putting on YouTube. Although they are open to the public in the courtroom, I'm not putting them online. Do either of you have any thoughts about that as you've interacted with other courts and approaches to that, or any thoughts on that?
I know we've had a lot of positive feedback from our victims from the time that the live stream started and continued, that it's just been really convenient for them not to have to leave work, not to have to be in the same courtroom with the defendant, and that has worked out really well.
What do you think are the pros and cons of courts around the state continuing to put hearings on YouTube? Do you think that should continue or not?
Well, from my perspective, the activity about putting it on YouTube or on Zoom or Zooming things, I guess I may be more towards just having things on Zoom. When we went to the whole Zoom format, it added a lot of work for us due to the fact that clients no longer were required to come to the courthouse. Now in circuit court they are, so that we're meeting with our clients and we're actually in the courtroom. So that being streamed, I have no position on, or I think it's fine. But when it's just Zoom, for that year there when we were Zooming all the time, it was a lot of work because we were tracking people down and they weren't required, and everybody changes their telephone number every day, and it added a lot of work to us.
Any other thoughts on the pros and cons of that? And Melissa, do you have any objection to us continuing to put that on?
No, and I think that as far as the Zoom part, I think the hybrid has been really nice because each case has its own circumstances and needs. And I think the court has been good, as well as the defense attorneys, and talking about what the needs are and how to go about doing hearings. And I think that it's worked very smoothly.
Yeah, so far right now, most of our criminal cases, or just speaking for me, most of the criminal cases I preside over are in person, but some were using Zoom as a convenience for people, defendants and victims and lawyers and witnesses. The civil cases, most of it is on Zoom, but we're allowing people in person, if that's what makes sense for their case. But stay tuned, because I was at a judges conference, and I can tell you my sense is that most trial judges in the state do not like putting anything on YouTube, and there are some very valid concerns about that. Some judges, and I'm one of them, I think it's a good thing for courts to have more transparency and accountability for what happens, and it's more educational for the community to know what's going on. But we're going to have to wait and see. I suspect we might get some rules or parameters from the Supreme Court about that. But as of right now, it's sort of up to each individual court. All right, any final thoughts on any behind the scenes stuff or our different roles in the justice system? Or?
Just that everybody came up with really great questions. I think it was quite diverse on all the subjects that were covered.
Okay.
It's fun. Thank you.
Yeah, and no, I enjoyed the opportunity, and I thought it was fun.
Yeah, and thank you both so much for taking over an hour of your time to have the discussion. It's fun for me to talk about these things with you and get your perspectives on it. And I'm sure that it's a lot of insight for anybody that'll watch these videos. So thank you so much for joining me for this. And as I say in all these videos, I'll see you in court. All three of us, we'll see you in court.
Thank you.
All right, have a good day.
Time to break this one down. This hearing wasn't your usual back and forth between adversaries. It was more of a candid workshop on how courtrooms really function, and in that sense, it was just as interesting as any contested case. Judge Aaron J. Gauthier once again anchored the discussion with a steady hand, blending professionalism with a little humor. He even shared a rare moment of vulnerability when he admitted that one defendant's comments made him so angry he had to stop himself from sentencing right then and there, choosing instead to cool off and reconvene a month later. That level of self-awareness is not only admirable, it's practical. Judges are human too, and acknowledging that keeps the process fair. He also had a playful aside about his favorite football team, which added some levity to an otherwise serious subject. Prosecutor Melissa Goodrich maintained her thoughtful, grounded approach throughout. She consistently emphasized fairness, especially when sensitive matters about defendants or victims came up. Her willingness to protect both sides' dignity, even acknowledging that sometimes defense attorneys do just as much shielding for their clients as she does for victims, showed a professional balance. On plea bargaining, she highlighted the tension of making decisions that can leave everyone a little unhappy, but still trying to land on fairness. That insight, especially about hearing weekly criticism of being too lenient or too harsh, sometimes in the same case, spoke volumes about the tightrope prosecutors walk. Defense attorney James Gilbert provided his usual mix of straight talk and comic relief. His explanation of why some matters go off the record, whether to protect sensitive client issues, personal scheduling, or even undercover work, was both practical and eye-opening. He was also candid about the trade-offs between retained and appointed counsel. The reality, as he explained it, isn't about quality of representation so much as volume of cases and time available. That was a valuable peek into the workload of public defenders. He also didn't shy away from discussing plea bargaining from the defense perspective, noting the benefits, the risks, and the occasional tough decision when clients face long odds at trial. His comment about clients sometimes talking themselves into trouble at sentencing was delivered with a grin, but it rang true. Sometimes silence really is golden. The overall courtroom atmosphere in this discussion was collegial, occasionally lighthearted, but always grounded in respect for the system. Off-the-record conversations, judicial temperament, and plea deals might sound dry, but here they became practical lessons in why courts look the way they do from the outside. It was less about drama and more about the mechanics of justice. And the candid tone from all three made it surprisingly engaging. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.